Yeah. All right. So yeah, again, the makeup. The only date that really changes is Monday. I'm sorry, Friday. This upcoming Friday, the 5th, we have a class. So you have me 3 times this week if you can bear it. But that we have to do to sort of make up our schedule. Okay. All right. Any other questions before we get started? Okay. I wanted to flag one event for you. I know you guys are super busy, but on Thursday at 12:15, the Career Services Office is holding a panel on clerkships. You may not know what a clerkship is. Judges often hire law students directly out of law school. It's called a clerkship. It's usually a 1-year position or 2-year position. You can clerk at the trial court. You can clerk at the Court of Appeals. You can clerk at the state Supreme Court. There are many different types of clerkships. It's a very important job. I had 2 of them. I clerked for a trial court and an appellate court. I would strongly encourage you to consider clerking. If you don't know anything about it, that's fine. You're just one else. But Thursday at 12:15, we're having a panel with 2 of our most distinguished alumni, Justice Ava Guzman, who's on the Texas Supreme Court, and Judge Reed O'Connor, who's on the Federal District Court in Fort Worth. We don't have many prestigious judges like that on our bench from our law school. We have a couple. And they're coming to South Texas by Zoom, of course, to talk to you all about clerkship. So if you can make some time Thursday, 12:15. All right, that's my plug. Bennett, I see your hands up.
What time is our makeup class on Friday?
Same, 9.
Oh.
Yeah, the way we're doing the makeups is whatever your class is on a Monday, that's what time is on the Friday. So you probably have some other makeups that day as well. Maybe not, I don't know, but at least for mine you do. Yeah, so again, the makeup is Friday at 9 o'clock. That's going to be class 13. I'll put a link to the syllabus again. Yeah, I just update the Google Doc. It's easier than sending out revised PDFs because it's very frustrating to keep track of revised documents. So there's the document. That's our syllabus. That's the entire semester. While I have this document up, I've uploaded to our class notes folder a topic. Usually I'm sharing with you all case summaries, but I'm going to start putting together what I call topic summaries, where I take a topic we covered, and my hope is to make it easier to understand. I put one up late last night, perhaps too late, I think, on life estate and fee simple. I see a bunch of you already have it open. I'm going to try and put one up on reversion and remainder, hopefully by class on Wednesday. If I don't, I apologize, but these take a very long time to prepare. It's really tough to distill a topic like this down to like 2 pages, or just a little bit more than 2 pages. So I'm going to try to get one done on reversion and remainder this week. I don't know when, but I'll get it done. But I encourage you to go through the topic summaries as well as the case summaries. Again, we don't have nearly enough time in class, as much time as I'd like, so I write these for your benefit to try to make up for any gaps that we miss. So these are considered part of the curriculum. You need to know them just as well as whatever I say in class. They're not short. They're a couple pages, but they will really, I think, clarify what you need to know. Most of the case summaries you buy from commercial sources are not very good. You don't know who writes them. May not be law professors. These should have authors. Sometimes they do, sometimes they don't. So these are some things which at least you know a person who's grading you wrote. So at least that's helpful for you to know. Alrighty, guys. Anything else before we get started? All right. Let me let me do a mini review before we get started. And by the way, today is all review. If you noticed, I'm sure you noticed, there was no new readings. Yes, you're smiling. That was, yeah, thank you, thumbs up. That was very deliberate. I find that this topic, again, is the hardest in the entire semester. And I'm not trying to intimidate you, but I'm simply giving you the facts year after year. And if today's class, I'm calling class number 11, isn't going to make sense to you, by class 13, you're going to be completely lost. So I want to go very slowly and very deliberately. All right. By the way, here are the lecture. I'm giving you a lot of links today. I'm sorry, but we have a lot of links today. Here are the class notes for class 11. So you'll have it for today. All right. So far, we've studied two types of present interests and two types of future interests, right? One present interest we study is the life estate. The life estate lasts for the duration of a person's life. If I say from O to A for life, I've given a life estate to A. A fee simple is the most simple, the most basic type of estate. With a fee simple, a person can control the present interest and also control the future interest. They basically have control of both sticks in the bundle. If I say from O to A, from O to A and his heirs, that means that O gave A fee simple, gave him the entire bundle of sticks, right? After a fee simple, there really is no special type of future interest. Why? Because A controls the future. If I say from O to A and his heirs, A can decide to leave Blackacre to his heirs, or A can decide to sell Blackacre and give nothing to his heirs. The important point is with a fee simple, the person who has the fee simple can control what happens to the property. But with a life estate, the person who has a life estate cannot control Blackacre after his death. He can control it during his life. He can sell it. It may be hard to sell it, but he could sell it in theory. But he cannot control it after his death. He does not have that future interest. Okay? Who does have the future interest? Okay? Who does have the future interest? Then we have to go to two different terms. All right? We've introduced two different types of future interests. Excuse me. We have the reversion and we have the remainder. All right? Students always get these confused consistently. If you're getting confused, it's okay. So look at question, go to the poll, please. Question 1A. All right? And this is going to be a short answer. So here's what we have. From O to A for life, period. Remember I said pay attention to the punctuation. The punctuation is very, very important. From O to A for life, period. The question is this. What interest does O have? All right. And whoever's next, just please raise your hand. Okay, that's in the classroom. I can't see who that is, but I see a person waving you down like you're like, Coast Guard, rescue, rescue, rescue. Okay. I'll call you about 5 seconds, whoever that mystery hand is.
It's Azrael.
Azrael. Okay, Azrael. Excellent, excellent. Thank you, sir. All right. Give me another 5 seconds. I'll go to Azrael. All right, Azrael. What is your answer here, my friend?
He has a future interest in a reversion.
Okay. That's right, but make it better. Reversion in
future
interest. I'm sorry?
A reversion in future interest?
Well, no, you're right. He has a future interest in reversion in blank. Fill in the blank. Azrael, let's just say it in plain words, right? At the outset, before O conveyed anything, what interest did O have?
Fee simple.
Okay, O had a fee simple. Very good. O chopped up his bundle of sticks, and he gave a life estate to A. Right, Azrael?
Yeah.
Okay. What was left over after O chopped up his bundle? O had a fee simple. He chopped up his bundle. What were the interests at that point? What were the present interests and what were the future interests?
There's a remainder.
No, you said before it's not a remainder.
A reversion.
Okay, so reversion is the future interest, and what was the present interest?
The life estate.
Okay, so let's just be very clear. Everyone, just take this down in your notes. I want this to be very clear for you all. O began with a fee simple. The question doesn't tell us that, but we presume it. Okay, we'll challenge that presumption later in the semester, but for now, just accept the presumption. O begins with a fee simple. Okay, O chopped up his bundle. He gave a life estate, which is a present interest, to A. So he gave one stick to A, and he kept the future interest for himself, which is called the reversion. Okay? So Azrael, one more time. A has a life estate. What happens when A dies?
It gets sent back to O.
Okay, it goes back to O. At that point, what is O's estate?
Back to a fee simple.
Yes. Okay, very good. So just help me out here, right? O has a reversion, but a reversion in blank. How do we describe it in its fullest regard? You said it after A dies, O has a fee simple again. So, I'm sorry, I interrupted you. Say it again.
Reversion and fee simple.
Perfect. Exactly right. The answer is reversion in fee simple. That's like the A plus answer. If you just give me O as a reversion, that's not wrong, right? That's like a B plus answer, right? But if you want the A plus answer, you say reversion in fee simple. Okay, so the answer to number 1A is reversion in fee simple. About a third of you put reversion fee simple. About a third of you put reversion, and the rest of you put something else. So about a third of you got the question wrong. Now, one person, I won't say who, said reverter in life estate. Please do not say reverter. There's a different type of a future interest called a possibility reverter. You'll see the word reverter later this semester. It's in the reading, I think it's for Wednesday or Friday, I can't remember. Don't say reverter yet. Okay? Yes, Derek.
Josh, so when you're asking for what is the remaining interest or what interest does X have, you want to know the specific interest, not a future or present interest.
Well, I want to know at the present moment, right? What interest does O have? That was my question, right? And the answer to that question is reversion in fee simple. That's the answer to the question. Okay. All right. Is there another hand up, or I think no, that was just that one. Okay. Everyone get this. If you don't get it, stop me now because we move on. Yes, Nicole, go ahead, please.
Sorry, I just want to make sure that I'm understanding it correctly. So for reversion, it's reversion in fee simple because O has a future interest that comes after life estate, and it goes back to him or to O because he's the grantor or to his heirs.
Right. It's a weird thing when you're describing the future interest. You're not only describing what the person has now, what they'll have later after the death of A. At present, it just says reversion, but it's reversion in fee simple. What that means is upon A's death, O will have fee simple once again.
Right.
Again, if you just tell me reversion, you're not wrong. That's good for 80, 90% of the way there. But if you want to distinguish yourself, you tell me reversion in fee simple. That's how I know you know your stuff. Okay? Because it's not always going to be in fee simple. With reversion, it probably will be, but not always. It could be something else. You could have a remainder in life estate, for example. Wendy, go ahead. I see your hands up.
I think you just answered my question. So we're dealing with the conveyance. Like after the conveyance happens, that's what interest we're analyzing for whichever person you ask us for.
Yeah, it's a weird thing,
Okay.
right? Let's say you write this transaction in the year 2020, and A is alive for 30 years, right? For 30 years, O will just be sitting there waiting on, I have a reversion and fee simple. I just can't wait for this guy to die because I get my fee simple back, right? It's you're describing what the person has when this conveyance is drafted. And that stays the same until the death of A, right? Now, Onya, I'll ask you the question because you happen to be in front of me at the moment. What happens if O dies along the way? Let's just say A lives to be 120. God bless him, right? What happens to O's interest if O happens to die?
It would go to his heirs.
O's heirs, that's right. So O's heirs would inherit that reversion. Exactly right. So again, this is like, I described like a cloud, right? There's this cloud floating over A for his entire life, just waiting for him to die. Think of like a vulture, like, like the desert, like a vulture circles over like a dying person who's out of water. They're just waiting for him to die so it's easier to get to. That's what a reversion basically is. You just wait for the guy to die, and then you swoop in and get your fee simple back. It's very violent, actually, right? It's like, usually at a death, you sort of mourn, you remember the person, you think well wishes. No, oh, he's dead, give me my property back, right? It's a very bizarre interest, but that's what we have. Does that make sense, Oni? Yeah,
Yes,
so
thank you.
cool.
That answered my question.
Yeah, call it a cloud, call it a vulture, call it whatever you want, but it just sort of circles around waiting. Zach.
Yes, sir. I get the point where Oni is saying that if O died before A, O's heirs get the reversion fee simple.
Right.
If O doesn't have heirs,
Everyone has heirs. Stop it. What did I tell you? Everyone has heirs. Please don't give me these sheets.
so the ancestors can become heirs.
Yes.
Gotcha.
Everyone's an heir. Everyone has an heir. Law students love asking what someone dies that heirs. I will never make that the question unless it's some sort of bizarre, end of the world, Armageddon, right? Everyone's dead. So just get that out of your head. It complicates things necessarily. I almost wish we didn't have to teach the if sheet, but it's there. Okay. Matt, go ahead.
So moving forward, if we just want to take it a little bit further and further develop our answer, we should not just say the future interest, right? We should
Absolutely not. No, that's basically wrong. If you just say O as a future interest, that's like a C.
Well, so I answered just reversion. So we should
That's
be
fine.
looking to
Yeah.
say reversion in or
Because
remainder in, so they can convey the.
look, we're going to have half a dozen different types of future interest by the time we're done. You can't just say future interest. You have to be more precise. Okay? Thanks, Matt. All right, everyone, let's do question 1B. What I put on as question 1B. Okay? Question 1B. From O to A for life, then to B and his heirs. What interest does B have? Okay, and this one's going to be, I think, for, I don't think Aaron's here. Or is he here? No, I don't think he's here. Oh, he's here. He's here. Okay. This will be for Aaron in about 15 seconds. All right, I think just everyone. Or Aaron, are you here? Yep. Okay, you're in the back. Okay. All right, Aaron, what is your answer here, sir?
A remainder and fee simple.
Okay, you said remainder fee simple. So let's break this down one step at a time. What interest does O have at the outset? So at the beginning of this transaction, what does O have?
A fee simple.
Okay, he has a fee simple, that's right. O then chops up his bundle. What does he give to A?
A life estate.
Good. O gives A a life estate. What's remaining in that bundle? What else is left over? So the present interest is life estate. What's left over?
The future interest.
Okay. And who does he give the future interest to?
B.
He gives a future interest to B. Does O reserve any future interest for himself?
No.
I'm sorry, say it louder, please. It's all hard to hear you.
No.
No. Okay, that's right. O does not reserve any future interest for himself. He gives a present interest to A, and he gives a future interest to B. So the entire bundle is given away. He gives the present interest stick to A, and the future interest stick to B. And Aaron, what do we call the stick given to B?
The
a remainder in, you said it before?
Life estate. Fee simple.
Which one is it?
Life estate.
What are the words there that give you a hint of what kind of estate it is?
His heirs.
Okay. When you see N is heirs, what should pop into your head?
Fee simple.
Okay, so do you want to try it again? What interest does B have?
A remainder
In?
in fee simple.
That's it. Okay, very good. Thank you, Aaron. A has a present interest in life estate, and B has a remainder in fee simple. Okay, now, how do you know it's in fee simple? You see the words and his heirs, right? And his heirs. Whenever you see the phrase and his heirs, you know you're dealing with a fee simple. Now, the harder question is, how do you know the difference between a remainder and reversion? You're gonna have to just memorize this rule. I have no other, way to describe it to you, but I'll just tell you to memorize it. When you have a life estate, and the future interest after the life estate goes back to the grantor, that's O. You have reversion. Right? When you have a life estate, and the future interest after that life estate goes back to the grantor, it's reversion. All right. But when you have a life estate, and the future interest after that life estate goes to a third party, such as B, you have a remainder. Right? When you have a life estate, and the future interest after that life estate goes to a third party, B, you got remainder. Law students have a lot of difficulty with remainders and reversions. Unfortunately, you just have to memorize that rule. There's no way around it. It's a very common mistake on the midterm and on the exam where people conflate. They mix up remainder and reversion. I can't help you with that. You're going to just have to memorize which is which. All right? Make sure you don't say reverter. Don't say reverts. Just say reversion. There's a reversion. There's a remainder. Just don't confuse reversion with reverter. Don't confuse reversion with remainder. They all begin with RE. It just is so easy to just mix up. And I'm begging with you not to mix up. You will. It happens every semester, but I'm trying to help you avoid that error. Okay? So the answer here is remainder and fee simple. A couple of you put remainder. Again, that's not wrong. It's just not the best answer. Remainder and fee simple. Okay, that's good. Someone put remainder in life estate. That's not correct. This is not a remainder in life estate. And I know why you put that. I think Aaron tripped and he corrected himself. When you see and his heirs, like, oh, that means after he dies, it goes with heirs, so it's a life estate. No. And his heirs always means fee simple. You have to just drill that into your head as hard as you can. You can't avoid that. Someone wrote fee simple after A's death. That's an accurate description of what happens, but that's absolutely wrong. It's called a remainder and fee simple. You have to use the language of what we have. Okay. Questions? All right. Yeah, Ben, go ahead.
Just want to make sure I'm making the distinction between remainder and reversion correctly. So if the holder of the future interest is the grantor, and it's going back to him, that is a reversion. If it's the
But just it has to be after life estate, right? It's not just the holder. It's not just when the grantor has a future interest. It's after a life estate because you can have different combinations. So just don't try and change my definition. I gave you a definition. It's pretty good. When you have a life estate and a future interest follows that life estate, if it goes back to the grantor, it's reversion. Don't try and shorten my definition because you'll omit an important part. I'm sorry, I don't do this often. I know it's like in torts, you have to memorize the 4 factors with a battery, or negligence, whatever. This is one of the things you got to memorize. I'm sorry. If you try and shorten it or rearrange it, you're going to miss something. Because you'll have cases where the grantor has an interest that's not a reversion. It's something else. It's only after a life estate. What you're seeing here is why this topic is so messy. Very often to figure out the present interest, you have to figure out what the future interest is. sometimes you have to work backwards. Sometimes you start at the end of the sentence and you work your way to the beginning of the sentence. It's going to get ugly. So that's why just follow me here. Just don't try and jump ahead. Okay. All right. I just thought of another example on the fly. Let's do 1C. Don't worry. We have a lot of questions. Today's review day. A lot of questions. All right, everyone. And this will be for Emily in about a minute or so. This is question I'm calling 1C. I just made it up, but it's good. From O to A for life, then to B for life. To life, l'chaim, right? What interest does O have? Not asking about A, I'm not asking about B, I'm asking about O. What interest does O have? Ooh, you guys are splitting on this one. Okay, that's good. By the way, this is the what I've described here is basically the fact pattern in our second case, Baker versus Whedon. Right? The conveyance here in its simplest form is what John Whedon gave to his beloved wife and his grandchildren. Kind of tweaked a little bit, but similar. All right. All right, I think we got just about everybody. All right, you guys did actually pretty well on this one. Okay, about 2/3 of the class got it right. All right, Emily, you here? Emily?
Yes, I'm here. Sorry, I was muted.
That's okay. All right, Emily, let's walk through this just one step at a time, okay?
Okay.
All right, so at the outset, what does O have at the very beginning? Just
At the very beginning, O has a fee simple.
okay, excellent, very good. Thank you, Emily. O then chops up his bundle. What does O give to A?
O gives A life estate.
Okay, excellent. The present interest in life estate. Okay, Emily, my next question for you is this. What about the future interest? O had a fee simple. He gives the present interest in life estate to A. What about the future interest?
He gives the future interest to B in life estate.
Okay, is a life estate a present interest or a future interest?
I'm sorry, a life estate is a present interest.
So what does O give to B?
O also gives B a life estate.
How can you have two life estates at the same time?
Well, A can die, and then B can take advantage. Well, B can get a life estate once A dies.
What do you call the future interest that follows a life estate that goes to a third party? This is why these definitions are important.
Per autre vie.
No. You're thinking of something else. You're on the right track. What do you call, I just gave you the definition 2 minutes ago. What do you call the future interest that follows a life estate that goes to a third party?
A remainder.
A remainder. So let's try this again. You're getting closer, I promise. So O had a fee simple. O gave a life estate to A. Okay. What happens after A dies, just in plain English?
What happens after A dies?
Plain English, yeah.
It goes back.
No. What happens when A dies? Just look at question 1C. In plain English, what happens when A dies?
B gets it.
For how long?
Until B dies.
Okay. So currently A has a life estate, and at some future point in time, B will have a life estate, right?
Right.
What do we call B's interest today while A is still alive?
I just want to. My mind just wants to say a life estate.
But it's not a life estate yet. It becomes a life estate in the future. What do we call it today?
A life estate per autre vie?
No. A life estate per autre vie is when you measure it by someone else's life. But that's still a present interest. That doesn't answer the question. All right, Emily, I'm going to move on. But you're really close. You're gonna hit yourself in the head in a minute or two. Angelina, you here? Angelina? Oh, you're in the classroom. I see you waving. Thank you. That's very, very dramatic. Angelina, help us out here. What does B currently have?
A remainder in life estate.
Yes. Emily's nodding. You're nodding now? Okay. B has a remainder in life estate. Now, Angelina, just tell us in just plain English, please. Why does B have a remainder in life estate?
Because he doesn't have the life estate yet. Right now, A has the life estate, but once A dies, then you will have the life estate, the present, and the present life estate.
Okay, that's exactly right. Let me just, if you couldn't hear, let me repeat it because it's just, you guys in the classroom are doing great. I can hear it, but maybe just other people can't hear it quite as well. So I'll repeat it. O had a fee simple. He chopped up his bundle. He gave to A life estate. That's the present interest. What about the future interest? He gave a future interest to B. The future interest is a life estate, but it's not a life estate yet. Currently, it's a remainder in life estate. Now, how do you know this is a remainder? Look at the definition I gave you 5 minutes ago. A remainder is a future interest that follows a life estate and goes to a third party, in this case, B. So it's remainder in life estate. I want you just to pause for a second. Remainder in life estate. Why do we say remainder in life estate? I don't know. That's what lawyers say. They said that for 500 years. A lot of the words we use here don't make sense, but it's remainder in life estate. All right. Now, Alec, you here?
Yes, sir.
Okay, Alec. Now the question gets harder. We know that B has a life estate at some point, right? What happens after B dies?
After B dies, it goes back to O.
What do you call the future interest after life estate that goes back to the grantor?
A reversion?
A reversion. So what interest does O have, Alec?
I put that he has a reversion in fee simple.
How do you know it's in fee simple?
Because that's what he's going to end up with after the reversion.
Why is that what he's going to end up with? You're right, but just tell me why. You're almost there.
Because he originally had the fee simple and he never gave up all the bundle, all the rights in the bundle. So when the life estate comes back to him, he once again has a fee simple.
That's exactly right. The answer here is reversion and fee simple. About 2/3 of you got that one correct, which is good. A couple people put reversion and life estate, which is not correct. Some people put remainder, that's not correct. So let me just break it down for you one more time. A has a life estate, present interest. B has a remainder in life estate, future interest. And then O has a reversion in fee simple. Oh, it's awful, isn't it? Right? This one sentence, go comma by comma, from O to A for life, A is a life estate, comma, then to B for life. The future interest after life estate to a third party is the remainder. So B has remainder fee simple. But it does not say that after B's death, it goes to O. It doesn't say it. You need to know this. You have to say, okay, when B dies, it's got to go somewhere. It doesn't tell us who it goes to. Oh, I know, that goes back to the grantor. And when the future interest after life estate goes to the grantor, we left with a reversion. And we know it's reversion fee simple because he gets the entire bundle back, right? With the remainder, you have a hint. It says comma then, right? Comma then. You know it's going somewhere later. But with reversion, there's no text to help you there. It doesn't hint. There's no hint for you. It just, you have to infer it. You have to understand property must go somewhere. Property has to be owned by someone at every point. At every point in time, there's be a present owner and a future owner. You have to always know who that person is. Okay, Angelina, I see your hands up. Let me unmute the classroom. Good.
So I was a little bit confused because I know that a question or two ago, you said that whenever there was a third party, that there would be it would transfer remainder. So can you clarify?
Yes, exactly right. There was a third party, B, who got the future interest, and that's remainder. But then after B's death, it's not going to a third party. It's going back to the grantor.
Yes, and in that instance, I thought that O would get a remainder.
No. Because O is not the third party. right?
No, be the third party, like versus it saying from O to A and then it being a reverter because.
No, don't say reverter. You said it. You said it.
Sorry, right. There being a reversion to O, but since B came into play, B being the.
Yeah. You're tweaking my definition, right? It's not when B is in play, it's when it goes to B, right? I use that word very deliberately.
Okay.
When there's a future interest after life estate that goes to a third party, it's a remainder. When there's a future interest after life estate that goes back to the grantor, it's reversion. Does this go to a third, after B's death, does it go to a third party? Does it go to the grantor?
Where's the grantor?
So what do we have here?
Huh?
What do we have here then if it goes to the grantor?
Fee simple.
Well, what's the future interest? What do you call the future interest after life estate that goes to the grantor?
A reversion and fee simple.
That's exactly right. Reversion, fee simple. Perfect answer.
Okay. Thank you.
Yeah, I know exactly what Angelina was asking. She said, well, there's a third party there, so it has to be remainder. That's not the definition I gave you. That's why I was sort of being mean to Bennett, saying don't try and tweak the definition. It has to go to a third party or go back to the grantor. How are we doing, guys? We just spent 40 minutes on 3 questions, right? I'm telling you, this topic sucks. But I hope these 3 questions will help clarify this issue for you a little bit. Matt, go ahead. Oh, yeah, you're in the classroom. I see you. Okay, go ahead. You're not on mute. You go ahead.
I'm just wondering, so whenever we talk about A's interest in this, is it life estate and fee simple, or is it just?
No, never say that. You can't have life estate and fee simple. A life estate's a life estate. It can't be in fee simple. That's an oxymoron, right? Life estate, present interest in life estate, period. Done. Yeah, never say, oh my God, when I see that in the exam, I want to rip my head out. If it's a fee simple, it can't be life estate. Yeah, is that another hand? I see. Is your hand in the classroom? Are you stretching? I think it's a stretch. Yeah, Derek.
Hey, Josh, so just on question 1C, if we were to add then to C for life, C would have a remainder in life estate.
Yeah. I guess that'd be question 1D. But if it said from O to A for life, then to B for life, then to C for life, right? I'm sorry. Yeah. So if it was from O to A for life, then to B for life, then to C for life, so you would have remainder in life estate. You can have as many remainders as you want. You can have 100 remainders stacked. It's awful, but you can do it. All right. Everyone with me? All right, let's move on. We've done this to death. I think we've beaten this to death. Go to page 260 in your book, please. 260 in your book. I want to discuss inheritances briefly, and I'll try to make this easier. What I have in the notes is multi-part questions. Is I basically simplified the hypothetical on 260. When a person dies without a will, and again in this class, everyone dies without a will, or they die with an incomplete will. Right? If you have a will that's very good, it's not very useful for us because you've decided what to do. In this class, what we care about is if a person dies without a will, or they have a will that's not complete or that's not clear, and the laws have to decide how to interpret that will. So consider this fact pattern, right? I'll just share the screen so we're all looking at the same thing for a minute. Okay. Oscar has 2 children, Alice and Ben. Why Alice and Ben? A and B. Sue me, right? Alice and Ben, A and B. Alice has a son named Adam. Okay. So Oscar has 2 kids, and he's a grandson named Adam. Those are all All of his relatives, right? So far. Okay. Then Ben gets married to Wendy. Is Wendy related by Oscar through blood? No. Wendy's only related to Oscar by marriage. The general rule is if a person's related to someone only by marriage, they don't inherit property through what's called intestacy. Intestacy means you die without a will, right? You're intestate. So you have the you have the wife of Ben. By the way, Wendy is W, right? Wife. You have the wife of Ben. She inherits nothing. Okay. Ben and Wendy have 3 children. These are 3 grandchildren. Betty, Bill, and Barbara. And they're all B to make it simple. Okay? We learned then that Ben dies with a will. He leaves all of his property to his wife, Wendy. That's fine. You're allowed to do that, right? No problem there. It's actually problematic that Ben tried to disinherit his children, but we'll leave that aside for a minute. Then we see that Oscar dies without a will. And to make this very easy, Oscar has $600. Not a very large sum, but $600. Okay? So I want to ask a series of, 6 questions fairly rapidly, but I'm looking for numbers here. Okay? Numeric answers. So question number 2. How much does Ben inherit? It's not a trick question. Or maybe it is. But how much does Ben inherit? I'm not seeing any answers. Are people not able to enter an answer? Okay, there they come in. Okay, good. I'm just looking for a number here. And this is going to be for, I think, Tyler, who's in the classroom, in about 5 seconds. It's not a stupid question. It's actually an important question. All right, Tyler, you here? What's your answer here?
I said 0.
That's the right answer. Why does Ben inherit $0?
Ben's dead.
Ben's dead. Read the damn question, people, right? 2/3 you put something not 0. That's wrong. Dead people can't inherit property, right? I know this sounds stupid, but if you're dead, you're dead, right? You can't inherit property if you're dead. In this question, Ben died. Ben can't inherit anything. I swear, I put this here very cautiously because I know people will screw this up in the exam. If someone's dead, they can't inherit anything. Tyler, A+ answer. The answer is 0. Never again you'll have the answer being 0, but that's the right answer. The answer is nothing. Okay. Let's look at question number 3. Okay. How much does Wendy, the wife, inherit? And this is going to be for Willie in about 15 seconds. All right, 5 more seconds and Willie's up. Yep, I see in the back there. I got you. All right, Willie, what's your answer here?
Because there's no mention of Oscar's wife, I assume both of his children, Alice and Ben, will get half of the 600.
I'm not there yet. How much does Wendy get?
300.
Why do you say 300?
For the reasons I explained.
No, you did explain.
That each of his kids.
When do you?
The wife would inherit what Ben would have received if he were alive.
That's not correct. What did I say a few minutes ago? What the wife inherits? I said it 2 minutes ago.
I may have missed that.
Yeah, you did. Yeah, it's in the book also. Zach, you there?
Yes, sir.
What does the wife inherit?
The wife inherits $0.
$0. Why is the answer 0?
Because she's not blood related, so the law assumes that she gets nothing.
She gets zip. I said it 2 minutes ago. The wife is real. Maybe the right wife is related by blood, in which case we have some other issues perhaps. But generally, the wife is not related by blood. I think that's a general observation. The wife takes nothing. Now, what Willie did was he was on the right track. He said, well, the wife steps into the position what the husband would have gotten. That's not correct. The inheritance skips the wife and goes to the grandkids, right? The inheritance skips the wife and goes to the grandkids. We'll get to the grandkids in a minute. That's, I think, question 6 or 7. But the wife gets 0. Again, when you marry into a family, you don't marry into the bloodline. You can't do that. You don't get anything through the inheritance intestacy laws. By the way, I'm saying this word which you may not know. Intestacy laws. When a person dies intestate, it's that they have no will, and the laws that govern inheritance for a person without a will are called intestacy laws. Just you gotta get your terminology. It's not like intestines, it's intestacy laws. All right, let's try the next one. Let's go to question number 4. How much does Alice inherit? How much does Alice inherit? This will be for Catherine R. Another 5 seconds and Catherine's up. All right, Catherine, you here?
Yes, I'm here.
Okay, Catherine, help us out. What's your answer?
Okay, so I put 300
Okay, why'd you put 300?
because whenever I was reading, I remember reading there's a thing called doctrine. I don't know how to pronounce it, but it's a doctrine per stupes.
Stirpes, yep.
Yeah, Stirpes, and that's basically saying that if a child of a decedent dies before the decedent, like if a child of the decedent dies before the descent, like the person dying, so if B dies before O,
Well, let's make this easier, Catherine. Let's say that Ben was still alive, right? And let's say Oscar had 2 children, Alice and Ben. Let's say Ben's still alive, and there's $600. How much would each of the kids get?
they would split 300 and 300.
Okay, so Alice gets 300, and then Ben would get 300. Does it matter to Alice whether Ben dies? Does her share change?
No.
No.
I guess no.
Well, you just said 2 different things. Which one is it? So you said a minute ago, Alice gets $300 if both kids are alive. Does Alice suddenly get more money if her brother dies?
I guess it depends on how many kids he has.
Does Alice's share change ever, or does she only ever get $300?
I'm going to say Alice's share doesn't change.
Does not.
It does not.
Okay, that's correct. No matter what happens, Alice's share is $300. Whether Brian's alive or dead, I'm sorry, not Brian, whether Ben's alive, I keep my B's mixed up. Whether Ben is alive or dead, whether Ben has 18 children, it makes no difference. Alice will only get $300. That's the most she'll ever get. Okay, so the answer is 300. About 2/3 you got it right, which is good. All right, good job, Catherine. Okay. Alice gets $300. Okay. Let's try question number 5. How much does Adam again is the grandson, Alice's son, get? How much does Adam inherit? This is me for Pierce in about 15 seconds. All right, Pierce, you here?
Yes.
All right, Pierce, what does Adam get?
You said Alice is dead now, right?
No, Alice is alive. Alice is alive.
Nothing?
What?
Is it nothing?
It's 0. Why is Adam get nothing?
Because Alice is still alive. The 300 would go to Alice.
She's the child of Oscar. She gets the entire $300. Adam gets 0. That's right. Good job. All right. Now we move on to Betty. Betty was the first daughter of Ben. How much does Betty get? And this will be for Brian. About 15 seconds. All right, I think I got everyone. Brian, you here?
Yes.
How much does Betty inherit?
I put 100
Why'd you put 100?
because Ben was supposed to get $300, but she's dead.
Right.
And so they have to divide it up into 3. You know.
And why into 3?
Because there are 3 children. He had 3
children. So Ben's share would have been $300. Ben has 3 kids. So how much does each kid get?
$100.
Okay, so then help us out then. What's the answer to question number 7? How much does Bill inherit?
100.
And how much does Barbara inherit?
100.
Exactly right. Thank you very much, Brian. So here's the breakdown. Alice gets 300. She gets half. Betty gets 100. Bill gets 100. And Barbara gets 100. Right? So Bill's kids took his half share and divided by 3. I know you're going to hate math. I'm sorry. What's 1/2 divided by 3? 1/6, 1/6, and 1/6. What's 1/6 of 100? $100. Right. So again, Alice 300, Betty 100, Bill 100, Barbara 100. This is per stirpes. This is the phrase that I think Catherine mentioned a moment ago. Per stirpes. PERSTIRPES. Per stirpes. It means by the line, right? Where you go down the bloodline and you chop it up, however many people there are. You know, imagine if someone has, 18 children, right? Imagine chopping up Blackacre into 18 different parts. I give you $600. That's an easy number, right? Imagine actually chopping a piece of property up into 18 parts. When people die without wills, that's what happens. That all the heirs have to share the property. It's an absolute disaster. You can't share property with that many people, which is why having a will is a very good idea. Grant, go ahead.
I'm a little confused on why the wife is completely cut out. On page 259, the second paragraph, do you have the book handy?
I can pull it up.
I'll read it.
Yeah.
It says, today in all states, the surviving spouse is designated as an intestate.
Who's surviving spouse, though? Who's surviving spouse? Not Oscar's.
It's not Oscar's, right?
Right, yeah.
The fact that Ben is already dead before Oscar dies. Just Wendy's completely out of the equation.
Yeah. Let me just, Grant makes a fair point. When Wendy dies, I'm sorry, not when Wendy dies. When Ben dies, Wendy inherits whatever property Ben has. Okay? But Ben didn't have anything at that moment. Ben had nothing. He had no present interest, he had no future interest. Ben would not have received it until his dad died. So when you say the surviving spouse, you're right. But this would be the surviving spouse of Oscar. In this case, it doesn't seem that Oscar had a spouse when he died. Maybe his wife died beforehand. We don't know. But good point. I like people read carefully. It's actually very good. Okay. Everyone get the answers to number of questions 2 through 8. I probably won't come back to this topic for a while. I just wanted you to get this experience for going through these numbers, but they are helpful. Okay? Questions? Look at this. We spent almost an hour just on questions. I haven't went to the case yet. This topic I know it's rough. All right. We have 2 cases on the schedule for today. The first case is White versus Brown, and the second case is Baker versus Whedon. I encourage you to read the case summaries of both of these because we're going to have to go a little more quickly than I'd like. We have about 20 minutes left, but I think we'll go through both cases. All right, Bradley, I think you're in the classroom, if memory serves. Yeah, there you are, I see you. You want to give me the facts, please, in the first case from Tennessee, White against Brown.
Yeah, so basically what happened was there was a will from this Lizzie Lied, and it was a very last minute will that she created, where she basically appointed, I think it was her sister and then like one of her like nieces or something. It wasn't a close relative, but she gave a life estate. She wanted to give a life estate to one of them and then give the rest of her personal property to the other one. But the problem with the will was that she put in that she wanted to give the house to Miss White, but it couldn't be sold.
All right. Well, let's just hold on. Let me screen share because I think that the text here is important, right? So thank you for that, Bradley. So there are 4 sentences, right, that are relevant. Sentence number 1. I appoint my niece Sandra White Perry to the executrix of my estate. Right. Executrix is the female version of executor. Don't laugh, but dominator and dominatrix. You ever think about why different? Anyway, when a word ends in ix, that means it's a female. That's just, that's just the suffix. I appoint my niece Sandra White Perry to the executrix of my estate. Okay, that's number 1. Number 2. I wish Evelyn White was a sister-in-law, not related by blood, right? A sister-in-law is sort of like a wife, a stepwife, right? There's no blood relation. Under the laws of intestacy, Evelyn takes nothing. I wish Evelyn White to have my home to live in and not to be sold. And she underlined not, and she underlined sold. Then she also said, I leave my personal property to Sandra White. Personal property are like things around the house, like jewelry and books and various trinkets. There are no restrictions put on the personal property. Sandra could sell them if she wanted to. Sandra was the niece. Sandra was related by blood. Okay. And Sandra would take through the intestacy statutes. Then the will says, my house is not to be sold. My house is not to be sold. All right. Everyone got the sentences right. All right. Zainab, you here?
Yes, I'm here.
All right. Thanks, Zainab. Let me ask you a question, please. Forget this case for a minute, right? You're a first-year law student. You've been in law school now for about half a year. If you were to just read this will as a non-law student, just a random person, coming off the street, how would you describe Miss Jessie's intent? What did she intend to do here?
I would say that she intended to keep the house within, like, family. Does that make sense?
Do you think she trusted Miss Evelyn very much?
No.
No, she didn't. Why didn't she trust Miss Evelyn?
Because she wasn't she was a sister-in-law.
Oh.
Sister.
Yeah. So what did if you had to just ask Miss Jessie in your own words, what did you give Miss Evelyn? What do you think she would say?
She would say that she gave her the house to live in and stuff, but not actually to sell it.
Okay.
Not give
Good.
her that responsibility.
Okay. Now, do you think Miss Jessie knew what a life estate is?
Probably not. No.
Did you know what a life estate was last week or 2 weeks ago? No, of course not, right? So thanks, Adam. So we have a problem here, right? This is very common. When people write their own wills, they use words, I think, that describe their intentions, right? But they don't know things like life estate and fee simple and remainder. They just don't know any of this stuff. So they write it in their own words. And there's nothing wrong with that. It's a legal will. But then it comes to a dispute, right? Evelyn says she was given a fee simple. Absolute, right? And she can do whatever she wants to it. She can leave it to her heirs or she can sell it. Now, what about the nieces and nephews? Right? The nieces and nephews said, wait a minute, Auntie Evelyn. All you have is a life estate. That's fine. And after you die, we have the remainder. In other words, the nieces and nephews said that Evelyn had a life estate. And following the life estate, there was remainder. And under the state intestacy laws, the remainder would go in fee simple to the blood relatives, as the nieces and nephews. Jesse's will didn't say who the remainder goes to. But it's got to go to someone, right? And they say under the laws of intestacy, the remainder goes to the heirs at law, which would be the nieces and nephews. Who's right? Is this a conveyance of a fee simple? Or is this a conveyance of a life estate followed by a remainder? Now, the trial court thought this case was easy. What's called the Court of Chancery, or a chancellor, right? The chancellor thought this case was easy. The chancellor said, well, this is so easy, right? Jesse's will unambiguously gave a life estate to Evelyn. It says to live in, but can't be sold. Now, is that so clear? Can you sell a life estate usually? You can. Most people won't buy a life estate because it will eventually terminate, but you can sell a life estate. But the Supreme Court of the state reversed and said, no, it's actually ambiguous. Okay. Freddie, you here? Oh.
Yes, I'm here.
Freddie, how did the majority read the will? How did the majority opinion read Jesse's will?
That it was incomplete.
Okay, what do you mean incomplete?
I guess that the terms were ambiguous, and it was hard to know exactly where she wanted the property to go.
Okay, that's right. And so what did the court do with it? How did the court said, yes, ambiguous. We don't really know what you meant. It's got to mean something. How did the court interpret it?
They interpreted that that her nieces and nephews were her collateral.
Okay, that's true. That's an easy point. But how did the court interpret the will? What was Jesse's intent? How did they interpret it?
They interpreted that she wanted the property to go to her nieces and nephews.
No, you're not quite. Catherine, how did they interpret the will?
Well, when they said that by reading live-in, it sounded like she was conveying a fee simple, but then the phrase not to be sold was saying that while she did have the fee simple, she couldn't sell it, so she was kind of putting a restraint on her.
Okay, so we have two different ways of reading it, right? One way of reading it is it conveys, a fee simple absolute, which is you can do whatever you want with it. Another way of reading it is you have basically a restraint. Restraint and alienation. That just means a restraint on selling it, right? How should the court read it? As granting a fee simple absolute, or as granting something with a restraint and alienation? How does the court prefer to read it, Catherine?
They prefer to read it as a fee simple.
Why?
Because if they read it with the restraint, then that leaves the problem. Eventually she will die, and then it just continues to be an issue. But conveying it as a fee simple is in the better interest to the court, and there's no doubt. They say something about that if there's a doubt that it shouldn't be a fee simple, but essentially they just
that's very good. Yeah, very good. Thank you so much, Catherine. All right, so just follow me here. There are two ways of reading this estate. Reading the will, I'm sorry. Option number one. Option number one is she conveyed a fee simple with a restraint on alienation. Okay. Option number two is that she conveyed a life estate. All right. the courts will generally prefer a fee simple over a life estate because it handles both the present and future interests, right? When you convey a fee simple, we know what happens after the current landowner dies. When you convey a life estate, it's messy. You have all these nieces and nephews running around. You don't know who they are. Let's just follow the simpler path. That's why they call it a fee simple, right? So if there's a choice between a fee simple and a life estate, in the courts of Tennessee, they prefer a fee simple. I think that's probably the rule just about everywhere. Most courts will prefer a reading that takes care of the entire estate. Well, that's the first point. But then we're stuck with this fee simple with a restraint and alienation. And you might ask, Josh, how can you have a fee simple with a restraint? Doesn't fee simple mean you have the entire bundle of sticks, right? Doesn't fee simple mean you can sell everything? Usually. And the courts actually say that if you have a fee simple with a restraint, that fee simple goes against public policy. Remember public policy? It's this vague concept of where things are bad. So what do the courts do? The courts say if you have a fee simple with restraint and alienation, the courts take out a blue pencil and they just cross out the restraint. They just cross it out. They pretend it's not there. And they basically convert a fee simple with a restraint to a fee simple absolute. So in the end, the court says that Jesse conveyed a fee simple absolute to Evelyn. The nieces and nephews do not have a remainder. They have zero interest in the house. None. Right? Everyone gets the majority opinion, right? Evelyn gets a fee simple absolute. The court struck out the restraint. I'll get to the dissent in a minute. Any questions in the majority? Yeah, go ahead, Derek.
So now we're introducing this fee simple restraint with the caveat that most of the time it's just going to get blue pencil.
I think that's right. The courts don't like restraints on fee simple, so the blue pencil comes out. All right, good question. All right, thanks, Derek. Any other questions in the majority? Right, the majority says Evelyn gets a fee simple. We just strike out the restraint and alienation. The dissent's like, what the hell are we doing here, right? Why are we using a blue pencil to cross things out? Let's just be honest here. Evelyn was not a lawyer. She did the best she could. She intended to convey a life estate, and that means after the life estate, the nieces and nephews would have remainder and fee simple. I find the dissent more persuasive. I don't know about you guys. I think I find the dissent more persuasive, but you know, people disagree. If I have a choice of a restraint and alienation or life estate, I'd probably go life estate because I don't like this blue pencil stuff. But you know, it's a majority opinion. We're a dissent, so I think both opinions are credible. But I don't know. I tend to favor the dissent, but what do I know? All right. 5 minutes left the other case. Ugh, I have to rush it. All right. Any other questions on White v. Brown? Yes, Bennett, go ahead.
You were saying that the nieces and nephews hold a remainder.
If under the dissent's view, under the dissent's.
Okay. So are they considered third parties then?
Yeah.
Okay. They wouldn't be heirs? They wouldn't be considered heirs?
Well, they're heirs, but they're third parties. They're not the grantor.
Okay.
The grantor is dead, actually. So I was waiting for someone to ask this question. Usually, when someone's dead, there's not going to be reversion because they're dead. You know, it can go back and they're dead. So they're leaving it to the nieces and nephews, to the third parties. They're considered heirs at law.
Oh, okay, I was reading like, the owner conveying. I just read that and his heirs into that automatically, but I guess that's incorrect.
No, and his heirs just means fee simple. But okay. Here we're dealing with remainder and fee simple for the nieces and nephews.
Okay.
All right. Let me try to. I'm gonna have to do the second case a little quickly, so you'll need to read the case summary after class to fill in some gaps. This is a sad case. I always get people get sad reading this one. I always get sad reading this one, right? So you have this guy John, He had a couple prior marriages and some kids from those marriages, and some grandkids from prior marriages. He had no relation with his kids. He didn't have a relation with his grandkids either, but seemed to have a soft spot for them. And then later in life, John marries Anna. John was 55. Anna was only 17. But by all accounts, this was a compatible marriage. I don't know what that exactly means, but it was compatible. He lived with her on their farm. She worked on the farm. She helped with the cows and the cotton and the soil and all the things you do on a farm. I don't know what you do on a farm, but she worked on the farm very well. And then before his death, he writes this will, where he basically says, I give everything I have to my beloved wife for her life. And if Anna dies with children, then the land goes to the children in fee simple. But if Anna dies without children, then it goes to my grandchildren from my first marriage. All right. So let's just write this one out. Okay. Let's just write this out. I'll put this in the chat, and this is in a document as well. From John to Anna for life, comma. Then to Anna's children and their heirs, comma. But if Anna dies without children, then to John's grandchildren and their heirs. Oh my God, you hate me so much right now. This is what a lawyer would have written if John had hired an attorney. They would have written something like this. But he didn't write this. He wrote it in his own sort of way. But let's take this one step at a time, just in plain English. So long as Anna's alive, she might have children. You may say, oh, Josh, how can a person in their 60s have children? In property law, we presume that you can have children at any age, even in your 80s. There's a concept known as the fertile octogenarian. I just ruined your days, I'm sorry. The fertile octogenarian. Even a woman in her 80s can have children. So we presume that Anna always can have kids. And as soon as Anna has kids, she cuts off John's grandkids, right? John's grandkids will only inherit the farm if Anna dies childless. If Anna has children, then the grandkids are cut out. So what happened here? John loved his wife, but he didn't trust her, right? If you trust someone, if you love someone, you give them a fee simple. So a Valentine's Day, a Valentine's Day card. If you love someone, say with a fee simple, right? If you love someone, give them a fee simple. John did not give his wife a fee simple. He gave her only life estate. And because she has a life estate, she really can't sell it. Why? No one will buy a life estate from an old woman, because as soon as that woman dies, the property goes to the grandkids, more likely than not, because she's not going to have any kids. So Anna is basically stuck on the property. And they go to court and they say, hey, can you order a sale of the property so that way Anna can just live off the proceeds? The trial court says, yes, let's order the sale. And the state Supreme Court says, no. Don't order the sale. Why? Because that cuts off the remainder of the grandkids. Their grandkids have a remainder, right? The grandkids have a remainder. Their remainder is if Anna dies childless. Now, I don't want to describe what kind of remainder it is. It's actually very complicated. We'll get there perhaps later this semester, maybe in about a week or so. But Anna's grandkids have a remainder. If you order the sale of the property, you cut off the remainder. And the Supreme Court says, we don't do that. We're not going to cut off the remainder. So as a result, the court says, well, maybe just sell part of it. But the important point is ordering a sale of the entire property cuts off the grandkids' remainders, and the court is not willing to do this. As things turn out, Anna lives forever, right? She lives to her 90s, and she actually outlives 2 of the grandkids. So eventually Anna died, and the 3rd grandkid inherited the property in fee simple eventually. But they had to basically wait, the cloud, right? The vultures waiting for Auntie Anna to die, and eventually they inherited the Blackacre in fee simple. All right, I am over. I'll start the minute poll now, but I will ask as well what questions you all have. Questions you have. Read the case summary for both cases because I had to move quicker than I want to, but I think the questions are actually more important than the cases here. What do you have? Questions? Going once? Yes, Elena, go ahead.
If Anna were to adopt a child, would that count as her?
If I read the husband's will, I would say Anna's children are her biological children. I don't know if adopted children would count. I have to think that through, but I don't think it would count. Good question. Anything else? All right, office hours as usual, 2:45 today, and I'll see you all on Wednesday. Thank you very much.